So you're thinking about signing a lease with a group of people? If so, look out for joint and several liability leases. Most leases in the District of Columbia are joint and several liability leases. In fact, if you have roommates, you are almost certainly on a joint and several lease.
But what exactly does this mean? According to Black's Law Dictionary, joint and several liability means liability that may be apportioned either among two or more parties or to only one or a few selected members of the group, at the adversary's discretion. In other words, joint and several liability simply means that all parties to the contract may be held fully liable for all debts incurred by any party to the contract, instead of just their own portion.
The idea behind joint and several liability lease clauses is that the group of tenants is treated collectively as one entity. The landlord didn't enter into 4 separate agreements with each tenant. The landlord entered into one agreement with all tenants as one party.
For example, the rent for your unit is $4,000 per month, and each tenant has agreed to pay $1,000. If one of the tenants does not pay their share of the rent, the landlord is not limited to suing the delinquent tenant. The landlord may sue any of the tenants for that $1,000, including those who already paid their own share. If the landlord does get a judgment for the $1,000 against you, you're entitled to sue your roommates to recover your loss. In a way, a joint and several liability is like a marriage. You got into it by mutual agreement, so if you want to get out of it, you either have to do it by mutual agreement, or you need a court order.
Think about it. Let's say you're allowed to get out of the lease without the consent of the landlord and the other tenants. Would it be fair if your roommates left without warning and you had to cover the entire rent amount?
Whenever there are multiple parties to a contract, unless the contract states otherwise, no individual party has the right to change or terminate the contract without the consent of all other parties. If you were to give a 30-day notice on behalf of just yourself, you'd be doing exactly that. Changing the terms of the contract without the consent of the other tenants and the landlord. If there is disagreement about vacating during a month-to-month tenancy, the only recourse is to go to the Civil Actions Branch of the District of Columbia Superior Court and get a judge to officially break your lease. Note, this process will take a lot of time, effort, and money.
Several years ago, I signed a joint lease for a 4-bedroom home with 3 other tenants. We're now month to month and I want to move out, but the other 3 tenants want to stay. Can I just give a 30-day notice and leave?
No, unless all the parties agree or you have a court order. Even if you move in after the lease was signed, you are almost certainly entering into a joint and several liability lease. For example, roommate swaps, roommate agreements, and/or lease addendums.
Take a look at these examples of joint and several liability lease language. So, what should you do if, like a large part of the district's population, you can't afford to live in the city without a roommate? There are precautions you can take before you sign your lease.
1. Ask your landlord to let each tenant sign an individual lease. Most landlords don't want to do that because it's much easier to collect one check than 4. You may have to drive a hard bargain or keep searching for a more flexible landlord, but it's likely to pay off in the long run.
2. Have an exit strategy. If you don't have a choice but to sign a lease with other tenants, see if you can include a termination provision allowing individual tenants to get out of the lease after the initial term expires.
3. Be a good tenant and roommate. If you've already signed a joint and several liability lease, your best bet might be to convince the landlord and your roommates to let you out of the lease in exchange for another tenant. You'll likely have to do the legwork to find the new tenant, and you may incur some application or background check fees, but it'll be cheaper than having to stay.
And finally, 4. If all else fails, you can always sue. Sure, it's not ideal, but if your roommates or landlord are not being reasonable, your only option may be to file a suit and ask the judge to sever your relationship with the remaining parties. You'll have to show a compelling reason why, so be sure to bring your evidence to court.
If you have questions or concerns regarding joint and several liability leases, contact the District of Columbia office of the Tenant Advocate. We're located at 2000 14th Street Northwest Suite 300N, Washington, D.C. 20009. Call us at 202-719-6560 or contact us on the web at www.ota.dc.gov.